Division bench item 1 for orders.
I have filed this application for that.
Sir, special bench. This is a special bench.
Yes, my lord.
Oh, Jagdish Bhuya, this matter. Okay, yes. We are passing an order.
Heard Ms. P. Burman, a learned counsel for the applicant, and also heard Madam
A Gayan
A. Gayon,
for
learned
respondent number
counsel
1.
for the respondent number 1, and Ms. Das for respondent number 2 and 3. This interlocutory application is preferred by applicant Jagdish Bhuya, the petitioner in civil rule within bracket AC number 17 of 1994. For rectification of the typographical error in the name of detainee number 7 in the cause title. And also in the paragraph number 4, 8, 11, 14, 15, 17, 19, 20, and 25 of the judgment and order dated 9/3/2023, passed by this court. Ms. Burman, learned counsel for the applicant, submits that the name of detainee number 7 in the cause title is mentioned as Bhoben Moran, Bhupen Moran, instead of Bhoben Moran. And also in the paragraph number 4, 8, 11, 14, 15, 17, 19, 20, and 25. And therefore, Ms. Burman contended that the name of Bhupen Moran in the cause title and also in the paragraph mentioned herein above may be corrected as Bhoben Moran. Ms. Gayon, learned counsel for the respondent number 1, and Ms. Das, learned counsel for the respondent number 2 and 3, submits that they have no objection in the event of making the appropriate correction as prayed for. Accordingly, this I stands to dispose of by providing that the name of Bhupen Moran in the cause title and also in the paragraph number 4, 8, 11, 14, 15, 17, 19, 20, and 25 henceforth be read as Bhoben Moran. In terms of this, I sense this one. Oh, yes, this will make necessary correction in the cost title.
Okay, will be corrected. That's it, due to my, my senior RX surgery is absent lordship and her name is also shown in the absent lordship.
Okay.
Can I kindly take the note on 7? It's a medical lordship.
Both sides are represented on the prayer made by learned counsel for the respondent. The matter stands adjourned today as the learned counsel holding the brief is not available. List on 7/2/2024. Have recorded presence. Both sides are represented. You want your name to be recorded?
Yes.
This is JC Chaudhary for the respondent is present.
For listing of one appeal. For orders. Any details.
Due to the court master, they will have to make adjustments.
Obliged.
I, for all those in criminal appeal 20 of the 2020, the time be allowed on Wednesday,
Okay.
on Wednesday, your lordship,
Hmm?
on Wednesday.
Wednesday. Okay.
Division bench item 2.
Your name? Your name? AK Hanan, counsel for the appellant, and Ms. S.H. Barara, APP for the state. Appeal under 374. Admit notice. Call for the records. The appellant shall take steps within 2 days for service of notice on respondent number 2 by registered post with AD. Post of a separate written of notice shall be submitted to the registry so as to enable the registry to process notice and hand it over to the London APP for service on respondent number 2 through jurisdictional. Which police station? Pragjyotishpur police station. The notice returnable on so and so. We'll give a returnable date after 6 weeks. I shall be considered on service of notice on respondent number 2 as well as receipt of LCR.
18-1, 19-3. Number 18-3. 18-3.
Three notice. 3 and 4 are also new matters.
See, it's all. Item number 2.
Your name?
D moment,
D.
M-O-M-I-N.
D. Momin
Yes.
for the appellant. Same notice. Okay. 18-3 returnable. Item 4. Issue notice. Mr. Ayu Chaudhary for the appellant. Here's Ayu also. Same order as number 2. 18-3.
Notice.
We should same order.
Obliged.
Item 5.
The paper book is ready, ma'am.
It will go for hearing.
Yes, ma'am. They have also received paper book.
Will do matter. Is service complete?
This report has not yet been received as per the notes. Dated 18/12/23. Finally. Get the notes.
The notice has to be.
Service report to be that is awaited.
But we'll direct the police station to serve it. Because without service, we can't proceed. This is a POCSO matter. Uh, There's a difficulty because the process was sent by registered post. Therefore, there will be no service report. You file written up steps. It will be sent through officer in charge.
There, matter. By an order dated 14/2/2023, madam.
Yes.
In Fish. Pro C, it was served.
No, no. It was because of this order, it was sent by registered post. Registered post, we can't, in criminal matters, we can't take deemed service. So you file a written steps, they will process it and give it to her. Service by hand. Mr. S.R. Ravadan, counsel for the appellant, and Ms. S.H. Boral and APP for the state. It is seen that pursuant to order dated 7/11/2022, notice on respondent number 2 and 3. But there should have been 4. 2 and 3, no, 2 and 3. 2 and 3 were sent by registered post with AD. So service report is not yet received. Accordingly, the court is intended to direct the learned counsel for the appellant to submit return of notices to the registry along with a copy of the memo of appeal. So on receipt of such process, the registry shall hand over the same to the learned APP for onward service on the respondent number 2 and 3 through the officer in charge of Goresar Police Station. Full stop. The notice is made returnable on 18/3/2024. So the next para. In the notice, it shall be mentioned that in the event the respondent numbers 2 and 3 desire them to be represented by the legal aid council, they may apply before the Guwahati High Court Legal Aid Committee. Full stop. Next para. In the event there is no representation from respondent numbers 2 and 3, the court reserves the right to appoint an amicus legal aid counsel or amicus curiae to represent the interest of respondent numbers 2 and 3. Next list on 18/3/2024. For that you write, the officer in charge of Goresar Police Station shall ensure that the service report is returned to the court through the office of the Public Prosecutor Assam at Guwahati High Court. So it says that a group is prepared and ready.
Item 6.
Lordship, kindly pass over the matter for timing.
The bail application is pending. There I have filed my affidavit.
Okay.
This day. NDPS matter.
After some time,
Item 7.
yes.
We have taken the stage in the DB case also, or service of implementation. But it has come, my lord, that he is not being found there, my lord. That is-
But she,
That the respondent could not be traced out. In spite of the paper publication also in earlier cases also in the IA. So there was an order on this post that in the CGM court, the case is going on the DB cases. So we have appeared that someone was being served, but it has returned back. Not only once, twice, my lord, that she could not be, but what we heard, my lord, from the neighbor, that she is in abroad or somewhere else, my lord. But I'm not sure about that, my lord. So another two, second, my lord. there also-
but there's a matter pending in the trial court.
This is a matrimonial case, my lord, the divorce was rejected from, against me, my lord. I prefer a divorce motion, my lord, that was rejected, my lord. That is why I'm before lordship for appeal. He has abandoned me from the marriage life.
Oh, my. Mr. Bhattacharya, I think you'll have to take a fresh notice on the, by newspaper publication for, in the main appeal. No, that is in, that is in continuation application.
Yes,
She may not like to, no, she may not like to contest that. But in appeal, when we are passing orders,
At that time, we have published it, my lord, that amounts to about 14,000, my lord, in paper publication.
you do it in one paper. This is, make it in, one SMS daily.
My lord, but it's for this purpose, right?
We can't help it.
But when the IA has been served, she didn't appear, and that was condoned, then
No,
again, my
no,
lord.
in appeal, she has no notice. Without notice, appeal can't be decided.
Even in the DB case, she is not appearing. In the DB case also, she is not appearing for a long time. All the
Can't help
money
it.
which has been deposited are there pending.
You are fortunate.
They are not withdrawn.
You are fortunate he is not contesting.
In local.
You will find a case listed, case decided by Supreme Court, where between the parties, there were more than 20 cases. Newspaper.
Come into play, my lord. He doesn't appear. Canals was like 1967.
No, registered post, that will not be there. It has to be sent to the correct address.
Correct.
If the address is not there, if she is not there, then you have to ascertain the correct
Yes,
address.
we have sent. In the trial court, my lord, the address which he has given, we have sent it there.
No,
In
no,
in the DB case also, my lord, that is written that she is not there.
no, she might have shifted, we don't know.
The police will make an inquiry to that.
It's a civil matter, police will not go there.
No, in the DB case, my lord. In the DB case also, the order is there, my lord.
No, but we are now handling a civil appeal.
I'll publish.
Mr. K. Bhattacharya, counsel for the applicant is present and submits that newspaper publication of notice was made in connection with IS Civil 1981 of 2019, but the respondent has not appeared. Post submitted that notices sent the address disclosed before the learned trial court. The process was sent in the address, disclosed in the disclosed before the trial court, but as per service report, the notices could not be served as no such person was located. Next para, be that as it may. In connection with this appeal, the appellant shall take steps for service of notice on respondent in a substituted manner by publishing in one Assamese daily having wide circulation. This is which place? Guwahati. Having wide circulation in Guwahati. Post of the steps shall be taken in a week from today, indicating the date of appearance on 18/3/2024. So the notice shall be published in the newspaper within 18/2/2024. You'll be able to take steps 18/2, so that 1 month, so that the respondent has 1 month to appear in the matter. Next for list on for that the appellant shall file an affidavit to bring on record the newspaper publication of notice. Next list on 18/3/2024.
Item 8.
I am appearing on behalf of respondent.
For hearing then,
My lord, may I, one clear, my lord. Let both the party maybe for, a attempt may be made for conciliation. There may be chance mediation or
you want to do it there at Silchar? Your parties will have to travel here, otherwise to Guwahati.
actually in Guwahati, it will be.
We are ready for it.
Hmm?
We are ready for it.
At Guwahati, suggest a date. Both of you agree to a date, or you take instructions and come back after some time.
Date
In the month of February itself, we are ready.
February itself. You suggest a date.
Seven.
27th February.
27th February. Okay. Mr. K.L. Gupta, counsel for the appellant, as well as Mr. S.K. Ghosh, counsel for the respondent. Next, this being a matrimonial dispute between the parties, the court is inclined to direct both the parties to appear before the Guwahati High Court Mediation Center in order to make an attempt for for settlement of their disputes through mediation. Stop. On a query of the court, both the learned counsel of both sides have suggested the date of mediation to be held on 27/2/2024. Accordingly, the counsel for both sides shall send a downloaded copy of this order to the parties, which would constitute a notice for them to appear in person before the Guwahati High Court Mediation Center on 27/2/2024 at 11 a.m. Next, let this order be brought to the notice of the Mediation Center Secretary, Guwahati High Court Mediation Center, so as to enable, so as to appoint a trained mediator to mediate the dispute between the parties. So we, the learned mediator may have as many sessions as may be required for mediation. Commencing from 27/2/2024, the mediator shall make an attempt to conclude the proceedings within 45 days and submit a report expertise list on 5th of April, 5th of April, 2024. Next, the copy, right? It is noted that the LCR is received. Based on 18. Court will not be issuing any notice.
Item 9.
Office not dated 25/1/24, my lord, LCR designation.
Record is received. So it will, we will direct the paperwork to be prepared. Mr. R.S. Mishra, counsel for the appellant, and Ms. S.H. Boral, APP for the state are present. As the LCR is received, the registry shall prepare a paper book. List after 4 weeks awaiting preparation of paper book.
Item 10.
Yes, Dr. Gogoi.
Now, earlier we filed this case on the basis of criminal revision petition. Thereafter, this honorable court has directed to go rectify and accordingly the appeal has been filed. The court is about. Now, this is the case. Today I'm facing the bail application. I given case number 1032 under section 389(1) of the.
You filed your objection?
Right? So can you give us two effect to find the same? My learned friend,
Yes.
Nadia of Prison, have said that we have not taken any steps, nor incident. Which steps, unfortunately.
That's okay. You see, you know how they,
My submission is that.
today she's not making that submission because the paper book is there in her table. And we can notice that from here. Correct.
the committee. Or date.
Yes, 2 weeks she is seeking. Yes, it's there.
Committee to
Just a moment.
বাঢ়িব নালাগে হে এলচিআৰটো বাদ দি ফাইলটো বেলেগ কৰি দিওঁ ফাইলটো বেলেগ কৰি এইখিনি থৈ এইখিনি নপঢ়া ইয়াৰ পঢ়া হ'ল
offline, no?
So do it within 2 weeks, otherwise, since Dr. Go is insisting. Both sides had represented. SSS brought an APP for the state. Praised for and is granted 2 weeks time to file objection in this interlocutory application. After 2 weeks, give a date. List on. You're not received paperwork. Okay. The criminal appeal section shall provide a copy of the paperwork to the learned counsel for the appellant. List on.
Item 11.
But Ms. Bora, what is the law on the point about objection?
As per you have said it, that is mandatory. 389 itself provides that in cases of imprisonment of more than 10 years to life, it is mandatory that the state shall file their objection. And after that, there is a Supreme Court judgment where it is said if the state does not file, then the Lordship will write that in spite of giving opportunity, state has not filed. In case Lordship allows for giving bail, in case Lordship decides that it's not a case for bail, then it's not required.
Oh, I can dispose my mind and then say that whether you file or you don't file.
Lordship can just.
No, that's okay. I'm just trying to understand. But I can't make up my mind and then say, here, please, I do the hearing. Yesterday, we were warned by Mr. Mishra. That should not be done. I'm just, because I'm not aware of that law, I'm just asking you. No, it's not required. Once you say that, because my brother is also accepting it. Yes,
This criminal appeal,
yes.
we take up with the criminal appeal 421 and 464/23 because the 6 persons were convicted and for the 3, another 2 or another by Suman Bara and the Kamaruddin might not be there. So these 3 items may be taken together, so we can hard at the.
Oh, okay. Mr. K. Bhattacharyya, counsel for the appellant, submits that 3 appeals have been preferred against the common judgment in appeal. And accordingly, he prays that all the matters may be taken up together. Accordingly, list this matter along with criminal appeal.
421 of 23 and 464 of 23.
Those are ready for hearing?
They have filed the objection against the bail, then we will see decide whether we pay for the bail or for final hearing. Let this person come.
Okay. After 2 weeks? Just after 2 weeks. Okay.
Item 12 to 18.
All our analogous matter Lordship can hear at one go, the hearing can be done.
In the meantime, I filed an interlocutory application.
So 23 application with 22 matters we are imparted today.
Since then. But other bail applications were rejected. Only 2 are left now, no?
This is a new one.
Only one. No, Rahmat Ali.
IA 1280 is pending. IA 1280 is pending.
Ah.
This is by,
Your Lordship, Rahmat Ali, criminal appeal 7.
you are the
Yes,
counsel.
Your Lordship, this is filed purely primarily on health grounds, Your Lordship. Admittedly, he is a patient of bypass surgery has been done on him. Your Lordship, he is critically ill. Very often he is brought to Your Lordship GMCH, Your Lordship, but he is not getting proper treatment, Your Lordship. That is the ground, Your Lordship. Very sick, Your Lordship.
You'll have to wait for some time because as per the newspaper reports, the Supreme Court is now deciding an issue whether people who are unwell can be given jail treatment by allowing their family members to take care of them.
Or else I can also bring a report from jail authority.
That can,
About their condition.
As far as marriage is concerned, perhaps they have filed one bail application that was rejected.
no, I have not.
Rahmat Ali?
Rahmat Ali, there are 2, 3. That's
Oh,
the problem.
acha. Maybe. One Rahmat Ali had filed.
Yes, sir. Rahmat Ali has not filed, Your Lordship.
Because it appears from the evidence that the lady who was killed, there is evidence to the effect that many the several accused, they gave her a dagger blow and she died. And your name is also referred by one of the witnesses.
Rahmat Ali is there.
You get a medical report. We'll call it,
I'll
okay.
get medical report from superintendent, from the jail doctor.
Which jail?
Kokrajhar.
Kokrajhar.
They were in fact distributed between two jails. One is in Kokrajhar, one is Borpeta. Or
He's in Kokrajhar.
In Kokrajhar, okay. This Rahmat Ali, okay. Mr. I. Hussain, counsel for the applicant, submits that this application under section 389 CRPC is primarily on the ground that he's not keeping, that the applicant is not keeping good health. Next para, accordingly, the Ms. S. Jahan and APB shall obtain a medical report of the, a current medical report of the applicant, namely Rahmat Ali, son of Bahadur Ali, who is stated to be currently lodged at District Jail, Kokrajhar. Stop. We permit the superintendent of District Jail, Kokrajhar, to send the medical report through email to the learned APP for being produced before this court. Next para, list on how much time? 15 days? Give a date after 15 days.
19th of February. Lodge.
All these other matters will be adjourned. Pardon me.
19th February.
Is the IA? No, but other matters will be listed because it's a default listing. It will happen. It will be listed. Other matters, tag it tag it along with IAS criminal 1280-2023 and list all the matters on same date.
Lordship will perhaps start with the Pathar hearing. So item number 6, which is left over.
Item
can-
19. Item 19.
No objection as far as the delay. is concerned.
28 days. This is POXO, but I'll have to issue notice.
So
There's a private respondent
requirement is there at every stage,
at every stage.
bailed, hearing, everything. As far as condemnation, perhaps that will also be included at every stage.
We think so because
This is
but
what.
there's a judicial pronouncement by the Supreme Court that they have right at every stage. Perhaps.
Let the notice.
Heard Mr. F. Hawk, counsel for the applicant, and Ms. S. Jahan and the APP appearing for respondent number 1. Next paragraph. By this application under section 5 of the Limitation Act, the applicant has prayed for continuing the delay of 28 days beyond the period of limitation in preferring the connected appeal. Next paragraph is as the offense, as the applicant has been convicted for commission of offense under section, punishable under section 6 of the POXO Act, taking note of the judicial pronouncement by the Supreme Court of India that the victim has a right to participate at every stage. The court is inclined to issue notice returnable on 18/3/2024 Next paragraph. No steps is required to be taken in respect of respondent number 1. So however, the applicant shall take steps for service of notice on respondent number 2 by registered post with AD as well as by usual process. Full stop. The usual process shall be processed and handed over to the learned APP for service on respondent number 2 through the jurisdictional Patasil Ambari Police Station at Guwahati. Full stop. Next para, the officer in charge of Patasil Ambari Police Station shall ensure that service report is returned prior to the next date of listing. List on 18/3/2024.
Consider after.
No, the appeal, we have not issued notice, so that order can't come in that IA.
Passed over item 6.
But I'm extremely sorry, Madam. Madam, it is But I'll just rely on one piece of evidence, my lord, probably which will demonstrate that this is probably not a case where this appellant is to be detained any further, my lord.
What is the police station case number?
Bongaigaon PS case number 451. Bongaigaon Police Station case number 451.
451, okay. Yes, what is the ground?
My lord, my ground for suspension of the sentence is that, my lord, in a case of NDPS, my lord, the first thing that the prosecution will have to prove perhaps is that the samples which are drawn from the alleged seizure are the same samples which have reached to the FSL, and the FSL must give a report that the samples are tested as positive of the contrabands as mentioned in the schedule, my lord. Now, my lord will kindly see, because this is, my lord, for suspension of sentence, therefore, my lord, I will not take a lordship to each and every, my lord, evidences. My lord, may kindly come to PW6. I had given a small compilation of the PWs, my lord, through whatever documents I had at my disposal. I made a compilation and it has been paginated as well, my lord. The PWs. Spiral binding, one spiral binding probably is there.
Yes.
My lord, may kindly come to page number PW6, that is page number 12. This is the person who has drawn the sample. My lord is there,
Yes,
page 12. My lord will see, I work in the office of the chief judicial, page 12.
yes. Please continue.
I work in the office of the chief judicial magistrate Bongaigaon on 22/5/2021 at about such and such. Bongaigaon police personnel brought suspected ganja in 3 packets. I prepared three
Just a
samples.
moment. Just a moment. We have the, do we have the LCR here?
Yes. I've taken it, Lord. I'm sending
Just,
back.
just.
Lord. Yeah. Dada.
documented.
Ms. Jahan, we are sending you back this record. Please go through it. We'll take it up after some time. In the meantime, because we would need that, need to see those orders and all about sealing, sending. Those are all supposed to be backed by orders of the magistrate.
Yes, yes. In fact, the matter was taken up once, then I had checked the records. There, what I find is 53A also samplings are done for before disposal of the articles. And, perhaps there are two facsimile here. One is.
No,
CTM.
nothing in you see, in these matters, there's nothing called perhaps.
Yes.
Either it's a positive or a negative. So you go through it, and because this is something you have to address us. We don't want to spend our time looking at the LCR and then finding those things.
Thought you can take it up on Monday then, because I have made some notes on this. How can there be two facsimiles on one sample? I did not bring the notes today, so Monday Lordship will take it up, and in the meantime, I'll also take this. Monday,
Monday.
positively.
Then let it go Tuesday, Monday, I'll be out of Tuesday.
It'll be out of station.
I tried to find out an answer to this, so I had made some note, I didn't bring it.
My lord, I have also given her a copy of this.
That also I
The
did not bring.
submissions which I'm relying for this, so my lord, she can come up with all the objections.
Even I didn't bring that.
Okay. Both sides are represented. Mr. Jahan and APP, we praise for some time to peruse the LCR and to address the court. So the court master shall permit the learned APP to go through the LCR next list on Tuesday. Tuesday will be 6/2/2024. We'll take up your matter, Mr. Mishra. Mr. Das.
Oh. Supply item 24 to 36.
After referring to Kalpana Rai, you were referring to the, you are suggesting that the putting of an association in the schedule is an executive act. This is where we stopped.
Now. Today, I have given a compilation.
Yes,
Compilation.
yes.
Everything is here now.
Okay.
The key compilation because we do not have to do it. We not have to do. I don't.
But this is something which is dangerous. First word which comes to the notice is infinity.
Yes. It is not the end.
May not-
Now, well, your lordship remember.
You remember the theory? Arguing is something else and hearing is something else. So he's having the burden of hearing you.
I specifically placed paragraph 8 of Arup Bhuiya's case. Arup Bhuiya's case, we have the next in this compilation. Very good, sir. 11.3. At page 7. Paragraph 8, we'll see in this compilation 3.
Compilation 3, yes.
At it starts at page 7.
Page
7.
7.
Paragraph 8 is what you find. Page 8.
Yes.
And fourth line, these 3 lines are underlined. However, the Tata code has convicted the appellate under section 3(5) of TADA which makes mere membership of a band organization criminal. Now, this is what one line I'm placing before an option. Now, if 3(5) of Tada, your lordship will see once more, my lord, with me, compilation 2. So kindly see Tada 3(5) at page 27 of compilation 2. Section 3 starts at page 29. Compilation, page 29, relevant is at page 30, subsection 5. A person who is a member of a terrorist gang or terrorist organization which is involved in terrorist act. Now, this line, I just ask a question, whether it only provides for mere membership of a terrorist organization or terrorist gang punishable, or there is more to it. Because the second part, which is involved in terrorist act, cannot be ignored. Because if that intention of the legislature was to make a mere membership an offense, then it would have been like section 10 of UAP Act. Section 10(1), section 10(a)(1), kindly see, my lord, at page 1, it starts in this only, and section 10, my lord, will get at page 9. At page 9. Penalty for being a member in the same compilation 10, page 9. Penalty for being a member of an unlawful association, where an association is declared unlawful by notification issued under subsection 3, which has become effective under subsection 3 of that section, a person who is or continues to be a member of such association. Now, this is punishable, because below it is all or. So, subsection 5 of section 3 would have been worded similarly. That if a person is a member of a banned terrorist organization, then he shall be punished.
There is another aspect of the matter.
Yes.
You see, this unlawful activities
Yes.
is one facet of disruptive activity, and this Tada includes terrorist and disruptive activities. So therefore, in this in the preamble to the act, it says an act to make special provisions for the prevention of and for coping with terrorist and disruptive activities. So therefore, it is inherent that disruptive and terrorist activity will be there, and otherwise they will not covered by Tada.
Yes. There is a case in Nalini versus state, Tamil Nadu case. It was involved in Rajiv Gandhi. So that's it. There an accused was charged under section 17 of UAP, like 70, but that was 3(3) of Tata. And very specifically, I have that case I made. Very specifically, Supreme Court said in paragraph 42 that if there is no terrorist act sent for trial, then punishment cannot be under Tata.
Oh,
That's very specific that I'll be referring to. But here, of course, there is no punishment under section 17, that is funding to the terrorists. The similar is there in subsection 3, but as your lordship has said, that the act itself says there has to be some terrorist
element there.
or terrorism. And terrorism, if your lordship will see in this UAP Act,
That is page 3, K.
Yeah.
Terrorist Act.
that is terrorist act, but terrorism and terrorist act also have been, says that terrorism will be understood in the way terrorist act is defined. But I'll play with some.
Okay.
Because
Because in one matter, the argument was that once the activities fall within the definition of section 15, even economic blockade would be an act of terrorism.
yes, because that you will, because it's mentioned in section, it's specifically mentioned.
Mentioned in,
55,
yeah,
that disrupt the life of the
citizens.
people, citizens. But can you not imagine a student calling a blockade? It's very common here in the northeast. There is some dispute with Nagaland, Assam will block Nagaland, no supply. They will block it at Bokajan. We have seen it. Similarly, something happens in Manipur with some Naga persons, they will stop it. Whether that will be a terrorist act, that has to be considered. That's why the aim and intention becomes very vital for interpreting these provisions. So I am on the point at the present, whether subsection 5 of section 3 merely provides for membership to be an offense. That will be only if the second line is left, which is involved in terrorism. Which is involved in terrorism, it cannot be ignored. It's part of the section. So therefore, there is a recent judgment. Problem arises when the decision which is relevant are not placed before the larger thing. I'll show, there is a decision of 2021. My learned junior, junior Farana is very intelligent. She able to take out this last night. And section 20 was interpreted. I can straightway take your lot. Your compilation 3. Page 87.
Mr. Mishra, just try to, I'm trying to, we are trying to recapitulate and understand your argument. It's clear that you are trying to distinguish between 5 and 20.
No, 5 and 20 are verbatim,
Okay,
except of one line.
so
regarding
therefore,
punishment. It's verbatim.
okay. And then you are also trying to say that there is a distinction between section 10,
1A.
1A,
Yes,
and you're,
A, Roman 1.
huh. And in that context, I'm just asking you a question. Like, for example, we take the state of Assam, we have Alpha here. Now, someone is charged for being a member of the unlawful organization or unlawful association.
Association will be on different.
Huh. So,
Association will be on different line, because as you know, said yesterday. And it's a recent decision of Arup Bhuiya, I'll call it Arup Bhuiya. There also they say that the entire procedure is there.
so it's okay, but you see, again, the same thing. Yesterday, I asked you same thing.
Yes.
That if a person is a member of a prescribed terrorist organization,
Yes.
then whether it is still required that this terrorist activity has to be proved again.
Because that is what it is, this what this section says.
Okay.
Section 3.5 again, kindly see again. On
No,
20,
we are reading it, but still we are trying to understand. That means every time, supposing a member of the proscribed organization is
Yes.
caught,
Yes.
then not only his involvement as a member, but the terrorist act of the organization itself again has to be reproved.
Again, what is subject matter of the that very trial? Now I'm telling you one thing. In Manipur, the Lordship has seen the schedule. There are 4 or 5 terrorist organizations, 4 to 9, if I remember
Yes.
correct. All in Manipur. Now, can member of all the terrorist organization be put inside? And say no need to prove who has committed terrorist act, because you are a terrorist organization. So all will go. Is that the intention of the legislature?
Okay. Now we understand the distinction.
Kindly see, the question is, whatever is given in the schedule, it will be deemed that not a word is additional or extra, or can be dispensed with, or can be, unless suppose your lordship decides to read it down. It has to be taken as it is. When the provision says both 20 and 3.5, it says being a member of terrorist organization which is involved in a terrorist act. Which is involved means which is subject matter of the trial.
Okay. Now we get it very clearly.
Yes. Look, there is no decisive pronouncement on UAP Act. Nowhere in the country the trial has completed subject to correction. Your lordship will be laying down the law. The law which has been laid down, either it's been laid down in abstract or with reference to the bail. There is all respect to Supreme Court. So your lordship will be laying down the law. That's why, my lord, my endeavor is to assist your lordship. And my only request would be that what I'm submitting, that should be recorded. So that once it goes up, whichever party goes, we don't know about this side because they are not to be seen. The other side will surely. That it should be decided forever.
Just clarify one more thing. Now, the same example which you gave of terrorist act in Manipur. So in that case, supposing there is a terrorist act in terrorist act, you are saying that omnibus everyone cannot be roped in. The query is, now supposing we give the organization name one, and the number one is one organization which has involved in a terrorist act. Now, because of that act, any member who is of that organization can be roped in. His specific involvement in the act is not required because of section,
Required. Why I'm saying,
because section 8 of the Evidence Act otherwise will be diluted.
it will not come at all.
It will not come.
Eight of the evidence it will not come. Only see, a bomb blast takes place today. Terrorist organization was declared a terrorist organization supposed in 2004. Suppose he has not committed this, or he has committed, can he be presumed to have committed this terrorist act also? Because his name was there in the terrorist organization, in the schedule. So therefore, I say, the terrorist act which is subject matter of the trial, they should be involved there. Otherwise, in 2004, you declared an organization as a terrorist act. To keep on involving, NIA will keep on involving till the eternity. That is not the intention. That cannot be the intention of the court. Legislation. Another thing which will make more clear, I placed part only yesterday. Can we come to the same compilation 2 at page 17? How terrorist organizations are added into the schedule at page 17. Compilation 2. Lakshmipati? I'm placing section 35, subsection 2. 35 is out of the central government to add an organization in the schedule. How the organization will be added, your lordship will come to 2 and 3. Yesterday 3 I did not place. The central government shall exercise its power under clause A of subsection 1 in respect of an organization only if it believes, that you can mark it, only if it believes that it is involved in terrorism. Terrorism. And I was telling your lordship that I'll show where the terrorism is. Definition, if your lordship can come to, at page 3. Page 3, then go back to 35 again. 3. 3. Terrorist Act. Terrorist Act has the meaning assigned to it in section 15. And the expressions terrorism and terrorist shall be construed accordingly. Now kindly see subsection 3. For the purpose of section 2, subsection 2, when the central government will believe that an organization is involved in a terrorist act, it is mentioned here. For the purpose of subsection 2, an organization shall be deemed to be involved in terrorism if it commits, participate, act,
of terrorism, prepares of terrorism, promotes or encourages terrorism, or is otherwise involved in terrorism. So it will be deemed, it's a deeming provision. On this provision, the central government may deem that yes, this organization is involved. On deeming provision, he will be put in the schedule. That would not mean that for any terrorist act which will come subsequent or any time, that he is involved, unless his involvement is proved. Now, I'll just substantiate by giving your lordship the first amendment to UAP Act. I'm sure your lordships must have seen the earlier UAP Act, which was, I call it a toothless UAP Act. I'll give that also. Kindly see, we have that.
We are of the same category that we say that before memory fades. By the time we read something else, this memory of earlier reading fades.
Biography written by Nariman.
That's why I'm reminding, before memory fades.
I'll be very happy, my lord, this, that your lordship lays down the correct law. I'm prepared to accept, my lord, if your lordship rejects my submission, because it should be absolutely clear. Now, the one that I have given, this is an old one,
Yes.
and amendment is of 2004 here. I
Okay.
can give the backgrounds. There was a lot of criticism of our country for two acts, Tada and Pota. Because they say without trial they are being kept. It's a different thing. PML does the same thing. So therefore, UAP Act was of 1967. They inserted everything. So they lifted verbatim collectively from Tada and Pota and put them here. And first time this schedule was made, which I have given it to your lordship. First time. If your lordship keep both together, then your lordship will be convenient. So 2004 amendment your lordship will take. This act may be called Unlawful Activity Prevention Amendment Act 2004. And your lordship will see the schedule. My purpose is to show the schedule to your lordship. The schedule is at page 40. Huh? Right. Oh, 13, sorry. Yeah. Got it. Your lordship will see from 13. From page 13, serial number 13. People's Liberation Army, PLA, United National Liberation Front, UNLF, all these up to minor 18. These are the terrorist organization of Manipur. In 2004, they have brought it. And something happens, this has happened in 2000, related to 2010. So 2010 Terrorist Act, whether they will be presumed to have committed just because they are in terrorist schedule. Therefore, section 3, 5 and 20 has to be interpreted as it is given in the statute. That is, any person being a member of terrorist or gang or terrorist organization which is involved in terrorist act, which is involved in terrorist act which is subject matter of the trial. Only then. And what I'm saying, I'm supported by a recent judgment. The issue that I said that my learned friend took it out at page 87, my lord, compilation 3, 87. Out of two judges, one is still there, one of course retired in June of last year. P. Fasal, you know, 87. Because it is 2 judges. Page 87.
Of the compilation three.
That's the-
87.
87. This is by 2 judges where necessary to look at the name. Justice Ajay Rastogi and Justice Abhay Srinivas Oka. Justice Abhay Rastogi retired last year in June. Justice Oka is still there. Now, Your Lordship will turn to page 95. Paragraph 10. The offense punishable under section 20 is affected when the accused is a member of a terrorist gang or terrorist organization which is involved in a terrorist act. Section 20 is not attracted. It's like Kalpana's family, which I place with Your Lordship. Section 20 is not attracted unless terrorist gang or terrorist organization of which the accused is a member is involved in a terrorist act defined under section 15. Section 20 provides for punishment of imprisonment for a term which may extend to life and fine. Somebody cannot be given life sentence just being a member of an organization.
So Mr. This paragraph 11 of this Thawa Fasal.
Come to
Okay,
that.
okay.
But before that, I want to place 38,
Yes, yes.
because 38 and 20 both have been discussed in paragraph. Uh, Now, 38, your lordship will find at page 17. Page of compilation 2.
Because in the order which was passed in a matter by this bench, it was a bail matter, but this
Always,
Thawa was referred to. And since it was a activity of disruption which falls within that, so therefore I took a different view.
here, this case, as well as Ranif, Dar, Guya, all bail matters.
Huh.
All bail matters.
All bail matters.
That's why I say that the pronouncement so far were only respect to the bail matters. There's no pronouncement on these in any appeal.
In any
finally
appeal.
being- Now kindly come to section 30.
But then you are aware of the principles of interpretation. It says that if a specific verdict has been given
No, no,
by
I
the
know
Supreme Court.
that.
Huh.
Your lordship will be bound,
Hmm.
this I know. But what happens if division bench, two division bench gives a different, like Justice Kanju, I'm not supporting Justice Kanju's judgment, three judgment, because of the fact that subsection 5 of section 3 of TADA does not make mere membership an offense. It is coupled with
Terrorist Act.
the commission of a terrorist act, involvement of terrorist act of the terrorist.
But
So it is not.
what is primarily coming to the mind is that if the act is a terrorist act done by a proscribed agency,
Yes.
then perhaps by implication of this 20, it's being a member of an organization who is involved in act. It doesn't say that the member itself will have to be involved in the terrorist act.
No, I'm not saying member
Hmm.
may not be. I'm saying that suppose a terrorist act has taken place today.
Correct.
The needle of suspicion is on UNLF.
Yes.
UNLF was declared in 2004. That I have shown. A terrorist organization. Now, can it be presumed that the present one they have done? I'm asking. And can anything in the law be presumed unless it's specifically prescribed? Provided nothing can be
The
presumed.
criminal trial, nothing can be on presumption.
Nothing. Section 43, one of the sections, there is a presumption against this, against the accused. I'm sure your lordship must have seen that. 43 capital E of UAP Act at page 21, compilation 2. There is presumption. Of course, rebuttable presumption. Lordship.
Hmm.
Presumption as to offences under section 15. In a prosecution for an offence under section 15, if it is proved that the arms or explosive or any other substances specified in the said sections were recovered from the possession of the accused, and there is a reason to believe that such arms and explosive or other substances of similar nature were used in the commission of such offence, or that by the evidence of expert, the fingerprints of the accused or other definitive evidence suggesting the involvement of the accused in the offence were found at the site of offence, on anything, including arms and vehicles used in connection with the commission of such offence, the court shall presume, unless contrary is shown, that the accused has committed such offence. So there is presumption, but it is presumption. This has been circumscribed to two happenings, which is mentioned in clause A and B of this section. Otherwise, nothing can be presumed.
So I'm saying that in 2004, an organization is declared terrorist organization. In 2010, something takes place. Person is arrested as a member of that terrorist organization. Whether the prosecution is supposed to prove the offense which has been committed, or you say, no, in 2004 you were declared, therefore you have committed this offense, it is proved and he is your member, will send him to life. This is one aspect. The other aspect is 38. Well, we'll find at page 18 of compilation 2 of the UAPF. 38. Yesterday also I said, but the cost of repetition I would like to place since we are now in the thick of argument on this point. But here it says,
With intention to further its activities.
offense relating to membership of a terrorist organization, a person who associates himself or professes to be associated with a terrorist organization with intention to further its activities commits an offense relating to membership of terrorist organization. So membership of terrorist organization is specifically provided in 38. There also, there is an addition that he has to associate or professes to be associated with. Without that, he cannot be convicted merely because he is a member. He is found to be a member. That is what in paragraph 11, Supreme Court has said. Now, and your lordship will see subsection 2. A person who commits the offense relating to membership of terrorist organization under subsection 1 shall be punished with imprisonment of term not exceeding 10 years. So membership of a terrorist organization under section 38 is punishable with 10 years. Membership of a terrorist organization, if it is interpreted that section 20 deals only with the membership of terrorist organization, then the question I'll put to myself, why life? Why should it be life imprisonment? Because offense will be then same, 38 and 20. Both membership of terrorist organization. I'll come to 11. Lordship asked me to take a lordship through 11. I'll take a lordship through 11 at page 95 of the person. The legal lordship notice the names. The party.
Page 85 of this compilation 2.
Yes, page 80. Compilation 3. This is new page. 3.
87.
Yes, 87.
Ah, yes.
Just on the lighter note. Swaha Fasal. I read it Swaha Fasal. Now let us go to 95. Paragraph 10 I have already placed, but I'll place together 10 and 11. The offense punishable under section 20 is attracted when the accused is a member of a terrorist gang or terrorist organization which is involved in terrorist act. Section 20 is not attracted unless terrorist gang or terrorist organization of which accused is a member is involved in terrorist act as defined by section 15. Section 20 provides for punishment of imprisonment for a term which may extend to imprisonment for life. Now here also your lordship, if your lordship do not read terrorist organization and read only terrorist gang, Then, my lord, I'm asking what will be happening, what will happen? Whether they will be required to prove the terrorist act. Because gang is not in the schedule. Gang is just defined, any person can form a gang. So they'll have to define the, yes, this is a terrorist act and this gang is involved. Section 20 cannot be interpreted differently for a gang and for terrorist organization. Now I'll place 11. Should I? On plain reading of section 38, the offense punishable therein will be attracted if the accused associate himself or professes to associate himself with a terrorist organization included in the first schedule. Why this is first schedule? Because schedule have been amended, and 2015 onwards, schedule has been divided into three parts: part 1, part 2, and part 3. Now, as it stands, so therefore it says first schedule. On plain reading of section 38, the offense punishable therein will be attracted if the accused associates himself or professes to associate himself with a terrorist organization included in first schedule with intention to further its activity. In such a case, he commits an offense relating to membership of a terrorist organization covered by section 38. Person committing offense under 38 may be a member of terrorist organization or he may not be a member of terrorist organization. If the accused is a member of terrorist organization which indulges in terrorist act covered by section 15, stringent offense under section 20 may be affected. So the Supreme Court itself is distinguishing between 38 and 20. 20 is stringent, naturally, because the punishment is life. Whereas 38 also membership, but it is only maximum is 10 years. That's how they have distinguished. If the accused is associated with terrorist organization, the offense punishable under section 38 relating to membership of a terrorist organization is attracted only if he associates with terrorist organization or professes to be associated with terrorist organization with intention to further its activities. Now, this is also required to be proved for 38, not mere membership. And I will show, Your Lordship, Arup Bhuiyan 2. This was submission made by the London Senior Counsel appearing for the state of Assam. Because there the question was only 10A Roman 1, no other provision. That was, even Roman 2 was not involved in Arup Bhuiyan 2. I'll complete this and then. If the accused is associated with terrorist organization, the offense punishable under 38 relating to membership of terrorist organization is attracted only if he is associated with terrorist organization or professes to be associated with terrorist organization with intention to further its activity. This association must be with intention to further activity of the terrorist organization. The activity has to be connected with terrorist act as defined under section 15 clause B of proviso to subsection 1 of section 38 provides that if the person charged with the offense under subsection 1 of section 38 proves that he has not taken part in the activity of the organization during the period in which the name of organization is included in the first schedule, the offense relating to the membership of terrorist organization under subsection 1 of section 38 will not be attracted The aforesaid clause B can be a defense of the accused. However, while considering prayer for grant of bail, we are not concerned with the defense. So your lordship will kindly see the difference between 20 and 38. 38, he has to prove that he has associated or he intends to associate. 30, which over 20, which my lord contains punishment for life, doesn't have to prove anything because the terrorist organization is given in the schedule. Only prove that he is member and he'll be hanged or he'll be sent to life. Can that be an interpretation of section 20 or 3(5) of Tata? In my humble submission, no.
Take a break and come back.
Do you want to?
Lot have been said about section 20 and 38, madam. There is a difference, but your lordship will kind of find that in section 20,
Mr. Das was just giving an explanation of section 20. Yes, Mr. Das? No, we are trying to explain distinction between the two.
should I say,
You wanted to say something, please do it.
just 20 and 38. Your lordship will kind of find that section 20. Because just your lordship, any person who is a member of terrorist gang or terrorist organization, which is involved in terrorist act, just stop it. Section 20.
Yes.
Any person who is a member, gang or terrorist organization, which is involved in terrorist act. Who is involved in terrorist act, madam? Not a person. It's a terrorist organization.
That's what the court said.
Madam, my service is that it is a terrorist organization. Now, additionally, if any person, any other member, because it is the duty of the prosecution to show that he belongs, he is a member of that terrorist organization or gang. That counts the evidence. Otherwise, it is the terrorist organization who is involved in terrorist sector. That is why. And in section 38, shortly you will find that section 38 that a person who associate now he did not be a member. Maybe a person maybe a person outsider who professes who
No, but the heading is offense relating to membership.
that is it 80%. I am not a member. I am not. I profess.
No, you'll never be a member. Say X.
Anyway,
Say X.
but just-
We won't accept
Mr. X,
even that
Mr.
submission.
Mr. X, Mr. X, he is not a member.
No,
It
he
is
can,
not-
he can
it
make
is
his
not-
submission because I know him. He will never agree that the milk is white.
He will never agree that the milk is white. It will always be black. And he will never be defeated because he will never accept it.
But that
He
is a
will get defeated if he accepts. So after me, let him get it, because whatever he has said, it is provided under section paragraph 10, which I have just read it out to your lordship.
I'll make my special part.
So
Your
you make
lordship,
after me.
Yours is very short matter, that's it.
No, because Mr. Mishra has invoked the thought process. You see, somebody who does an act which is in furtherance to the to the
Activity.
activities of the terrorist organization, then he gets 10 years.
Yeah.
And a person who is merely a member, he gets life.
But no, here, there is again a writer, a person, number one, he is a member. Number one, if he does any terrorist act, being a member, he has to do certain terrorist act, then he will be additionally punished under section 16. You also will kindly find section 16. Section 16. Whoever commit terrorist act, so and so, so and so, so and so.
Okay, let Mr. Mishra complete, then we'll.
So if it is section 20, then 15 will not come. If it is 20, section will not come because he is already a terrorist organization in the schedule. And therefore, some person dies, no question of any death sentence, because section 16 deals with death sentence. 16 is always independent of section 20. Because as he himself pointed out, in 16, it is the gang or the organization which is involved in terrorism. In section 16, it is person.
It's a person.
Yes, who commits a terrorist act defined under section 15, and it will involve both. Person will be, an organization can be a person, an individual can be a person. 16 is different. Anyway, I'll start. So my submission was, my lord, that your lordship has seen in Fassel case, at page 1195, that it very clearly states that section 20 will not be affected at 25 unless terrorist gang and terrorist organization of which the accused is a member is involved in a terrorist. So involvement of a terrorist gang or a terrorist organization has to be in terrorist act. That will be signed for non.
You are referring to para 11 again,
Para 10.
para 10.
Yeah.
The offense punishable under section 20 is attracted when the accused is a member of a terrorist gang or a terrorist organization which is involved in terrorist act. Section 20 is not attracted unless terrorist gang or terrorist organization which is involved in terrorist act as defined under section 15. The punishment so and so. Therefore, your example that there are 5 organizations in Manipur, one is involved in the terrorist activity, members of the other 4 will not be attracted.
Because they'll go only after one. Now, let me just read Kalpanath Rai, just to refresh your lordship on that. So, only not. Kalpanath Rai, section 3.5 will also say similar provisions in same, except that punishment part, compilation 2 at page 75. Is also by 2 days time. I read it yesterday.
yesterday, if my lords recall, I placed section 32, where 3.5 is quoted at page 89. At page 89. Page 89.
Yes.
Page, paragraph 30, page 89.
Yes, para 32.
3.5 is quoted. So many times your lordship has seen 20, now your lordship will see this is almost verbatim, except one line. Any person who is a member of a terrorist gang or terrorist organization which is involved in terrorist act shall be punishable with imprisonment for a term which shall not be less than 5 years. This is not there. But it may extend to imprisonment for a life, which shall also be. So here also, a person, first requirement is must be a member of a terrorist gang or terrorist organization which is involved in terrorist act. Now, what the division bench said, my lord, in 1997 at page 90, 90.
Para 35 you were referring to.
There are two postulates in section 5. First, that the accused should have been a member of a terrorist gang or terrorist organization. After I recall, because this is the date on which Tata had come. This is the first, that he should be a member of terrorist gang or terrorist organization. Second, is that the said gang or organization should have been involved in a terrorist act, similar as that of Fasal case. Fasal case. And it further goes below and says, unless both postulates exist together, unless both postulates exist together, section 3.5 cannot be used against any person. The 97 interpretation of 3.5 and 21 Fasad case, similar. He will be attracted only if will not be attracted unless terrorist gang or terrorist organization of which accused is a member is involved in terrorism. So both similar interpretation of both these sections. Now, Lord, I'll come to Arup Bhuiyan. This is a 3 judges bench, which has overruled Ranif, Arup Bhuiyan 1, as well as Das. Indra Das, as well as 3 decisions were overruled here. And how this Arup Bhuiyan 2 was initiated, if your lordship will write the judgment, this also will be required. So I have brought that. My lord, take compilation 3 again.
Yes.
This was referred Arup Bhuiyan because of a review petition. Page 23A.
They have given this relevant here, because it is just to show how the Arup Bhaiya. This is also Arup Bhaiya, we can call it Arup Bhaiya 2, and the other one we can call it Arup Bhaiya 3. This is 2015-12 SCC 702. Kindly come to next 23B, paragraph 12. Regard being had to the important issue raised by the learned Solicitor General and Mr. Jaydeep, the learned Senior Counsel for the State of Assam, we think it appropriate that the matter should be considered by a larger bench, that the registry place the papers before the Honorable Chief Justice of India for appropriate order. Now, this is how Arup Bhaiya
3 years come.
matter 3 can say or came along, which I have enclosed. Your Lordship will find at page 24. On there. The relevant paragraph I'll place is paragraph 8. My lords will get at page 25. The short issue before the bench is whether judgment in Ranif Arup Bhaiya have been correctly decided and whether active membership is required to be chosen over and above the membership of banned organization UAP 1967. Another issue which is required to be considered by the bench is whether American decision concerning freedom of speech referred to in Ranif, to which this court agreed, would have been relied upon while considering the right to freedom of speech available under the Constitution of India, more particularly Article 19(1)(c) and 19(4) of the Constitution of India. Another question which is required to be considered is whether this court was justified in reading down the provision of section 10(a)(1) of PAC without including the government of India as the party, and more particularly with the constitutional validity. My lord, my submission would be that this court, this bench, decided only 10(a)(1), Roman 1, which makes mere membership of an unauthorized association an offense, which in Ranif and other cases it was held that mere membership cannot be an offense, referring to American decision that guilt by association is not an offense. It will be otherwise, it will be violative of the fundamental right. The court accepted. So here, the question is not whether 3(5) was correctly decided. 3(5) they take last, just passing reference. This case is on 10A1. Therefore, the law laid down has to be confined to 10A1, which I have no dispute.
The decision in these three cases which are overruled is 10A1.
10A1, in one of the cases, Arun Mia 1, it is 3-5, where it is said that mere membership has been provided in the section as punishable, which itself was not correct, which is misreading of subsection 5 of section 3. Because here, madam, the government of India was 3-5 had gone, already it's gone. Tata is over. So they were not interested. They were interested in section 10A1, which I have placed before your lordship, and which is also quoted here at page 29, your lordship, to just have a glance and then I go to the other.
It's okay, we take it from you.
It's here in 29.
Hmm.
In this compilation itself, 29. 10A1 is and continues to be a member of such association. Others have not been done. Specifically, it is Roman 1, 2, 3, and 4 have not been considered, not subject matter of yes.
So unless he resorts to violence is 10A1. So that interpretation is,
That interpretation, 10A1 was interpreted and mere membership cannot be an offense. And it was read.
unless he resorts to violence.
No,
that
unless
is-
the other things are,
Hmm.
unless things are. Because question of violence is not there in 10A, in 10B it is there, which is not a subject matter. In section 10B, your lordship will find the violence is there.
No, in this para 49 you are showing us, here also this is mentioned. That's why I'm asking you.
59,
Page para 49,
para 50,
page 29, para 49.
51,
Huh.
the section 10 is quoted.
No, that's okay. But before that, in para 49,
Yes.
it says, in view of the reading down of so-and-so, mere membership of the violence,
49 says,
unless he resorts.
but it is not there. It has been read down. It is not there in 10A1.
It's 10B.
Only mere membership. Nothing can be read. Under section 10A, Roman 1, nothing more can be read. The court wanted to read something that was said, struck out, overruled. So my purpose of saying is that 3-5 was not a subject matter of this. The entire focus was on 10A Roman 1. Which we are not concerned, we are concerned with 20. Now, as I said about executive dictate, the submission of the Solicitor General, that becomes important. Your Lordship will go to paragraph 14 at page 27. At page 27. Placing 14, page 27.
27.
Page 27, paragraph 14. This is the submission of the learned Solicitor General.
Yes.
Taking us to the relevant provision of UAP on declaration of any organization or a public association as unlawful association or as unlawful.
namely section 3 to 6, that Solicitor General has submitted that apart from perusal of the aforesaid provision of like sections, it is clear that the declaration of an organization as an unlawful organization is not on the basis of executive dictate, Lordship Nalima. Not on the basis of executive dictate. This is what I have been saying. Whereas terrorist organization declaration is on the basis of executive dictate. It is submitted that such a designation is actually a product of robust adversarial process wherein ample opportunity is given to the organization to appear to the better sense of judicially trained mind in order to justify its aim and objective and activities being legal and not unlawful within the constitutional setup. It is submitted that the same must have a bearing while deciding any question of criminalization of the mayor membership. There is a provision, the entire procedure is mentioned. And the court was convinced because of that. I'll take your lordships to 96 and page 51 of the compilation, 96. Yeah, I think we got 96 is at page 31. Now, so far as the submission on vagueness of section 10A, Roman 1 is concerned, as observed herein above, an association is declared unlawful after complying with all the requirements under section 3 and 4 of UAPA, as discussed herein above. A person who is a member of such unlawful association is as such aware of the declaration of such association as unlawful association despite the same. If he continues to be a member of such unlawful association, which is indulging in unlawful activities or acting against sovereignty and integrity of India, his intention is very clear that he still wants to associate with such association which is indulging in unlawful activities and acting against the interest of sovereignty and integrity of India. The language of section 10A, Roman 1 and procedure to be followed under section 3 and 4 of the Act before any association is declared as unlawful are very clear. There is no vagueness at all as sought to be contended by so and so. Therefore, section 10A, Roman 1 does not suffer from any vagueness or on the ground of unreasonable or disproportionate. There's no quarrel. I have no quarrel with this. 10A, can you see? 10A is punishable with 1 year. A member of unlawful association, the punishment is just for a year. Section 10 at page 9, my lord will grant it. The punishment is just 1 year. 2 years, sorry. Shall be punished with imprisonment for a term which may extend to 2 years. For 2 years, for being a member. Now, my lord, if your lordship remembers, I was telling my lord, the submissions made on behalf of the state of Assam by senior counsel.
Your Lordship, kindly come to page 28 of the third compilation, 3. This is exactly what is held in para 11 of Fasad case. Fasal. Fasad ही है. 28, paragraph 23.2. I'm not saying for a minute that there is a submission, so your Lordship, it will be binding on your Lordship. I'm not saying that there is a submission by additional by solicitor or by a senior counsel, your Lordship will accept it. But in this case, it was accepted. And your Lordship, I've just placed 38. And also paragraph 11 of the Fasad case. Similarly, it is in accordance with this submission. 23 to, my lord, I'm placing. It is further submitted that section 38 of UAP Act provides that a person who associates himself or professes to be associated with a terrorist organization with intention to further its activity commits an offense relating to membership of a terrorist organization. It is submitted, therefore, it is seen that in case of terrorist organization, a mere membership is not sufficient. But there has to be an act with intention to further its activity of a terrorist organization, which is not the case under section 10 with an unlawful association. This is what Supreme Court, my lord, held in 21 decision. Can you give me that Fasad one? Fasal case. Now, my lord, again at the cost of repetition, again at the cost of repetition, I'll submit that punishment for membership of a terrorist organization under 38 is not mere membership of terrorist organization. Something is more required, as your Lordship has seen in paragraph 11 of Fasal's case. The statute itself says that unless he associates himself or professes to associate, and the omission by the council also says that unless this is coupled, he will not be sentenced under 38. And after all this, he will be sent a maximum imprisonment for 10 years for being member of a terrorist organization. If section 20 is interpreted that he is a member of terrorist organization, therefore he should go to life, that interpretation, my lord, in my humble submission, will not be correct. The terrorist, it has to be shown that, look, the terrorist, which has, this is subject matter of the terrorist of this trial, and this act is committed by this terrorist organization of which so and so is a member. Only then he will be given life sentence. And if he is involved in the terrorist act, then he will be punished under 16. And I never said that member will have to be involved in terrorist act for the purpose of 20. 20 is very clear. It is either terrorist gang or terrorist organization which is involved in terrorist act, not the members. I never said that. So, my humble submission would be, my lord, there will be a dichotomy if the interpretation is given that membership of a terrorist organization in section 38 will be punishable with 10 years and membership of 20, mere membership of 20 will be life. So therefore, that's not a correct, my lord, submission. Therefore, on this point, my lord, I will conclude submitting, my lord, that section 20 cannot be read. Oh, I'm sorry, my lord. One thing which will bring in 3.5 that I forgot, that's very important. But this has been brought off the cuff, I will say. Paragraph 100 of this Arup Bhuiya, my lord, that 23 case. There it is. 100. At page 32. As page 32. Paragraph 100, this is the concluding part. Page 32. In view of the above, and for the reasons stated above, we hold that the view taken by this court in a state of Kerala versus Ranif, Arup Bhuiya versus Union of India, Indira Das versus State of Assam, taking the view under section 3(5) of Terrorist and Disruptive Prevention Act 1987 and section 10A Roman 1 of Unlawful Activities Prevention Act. Mere membership of banned organization will not incriminate a person unless he resort to violence or incite people to violence and does not act intended to create disorder or disturbance of public peace by resort to violence or reading down the said provision to mean, and over and above the membership of the banned organization, there must be an overt act of further criminal activities adding the element of mens rea are held to be not good law. It is observed and held that when an association is declared unlawful by notification issued under section 3, which becomes effective under subsection 3 of the section of that section, a person who continues to be a member of such association is liable to be punished with imprisonment, which may extend to 2 years and shall also be liable to fine. So reference of 3(5) is just a passing reference in my humble estimation. Because your lordship will see the expression banned organization is being used for both the section 3(5) and 3A Roman 1. Nowhere 3(5) has been discussed in the judgment. Even paragraph 8, which contain issues before the court, it is 10A capital A Roman 1. Nowhere, my lord, it has been discussed. And 3(5) otherwise also it's not like 10A Roman 1, providing punishment for mere membership of terrorist organization. So therefore, my lord, this judgment is for the purpose of laying down a law that section 10A Roman 1 virus is upheld. That's all. It will not spill over to section 20 now. Because 3(5) Tada was already repealed. Nobody was interested. It was not even placed in the judgment. I have gone through all looking for it. I did not get it. So my humble submission would be, my lord, that section 20 cannot be read as a provision which makes member of a terrorist organization, mere member of terrorist organization, an offense under section 20. As held in Fasal case, the Fasal case.
Please repeat again, section 20 cannot be read to mean? Huh. No, it's okay. You're trying to interpret that section 20 cannot be read to mean
Yes.
that merely,
To mean that mere membership of a terrorist gang or terrorist organization is punishable with life. Without a finding that the terrorist gang or the terrorist organizations are involved in a terrorist act. Without a finding that the terrorist gang or the terrorist organization is involved in terrorism. But one very specific submission. We forget that section 21 contains terrorist expression, terrorist organization. We say terrorist gang. Now what happens if the allegation is that Mr. A is member of a terrorist gang which is involved in terrorist act? Whether terrorist act will not be required to be proved because terrorist gang is not in the schedule. This is very important, my lord. This will be an external aid to the interpretation of section 20. What will happen if terrorist organization is not mentioned in? These will be the striking pieces for interpretation of section 20. So this point, I conclude on this point. Now the next point, we will go on, I'll go on. What are the evidence on the first requirement, that is member of a terrorist organization? That I will start at 2. One. Or if you want to, I can start
at 2?
at 2. And hopefully I'll finish today. Others will not take time. I have one more, this, other than that, there's similar matter, one matter there, that also. After that, I'm not.
You're not going to?
I'm not going to touch it. I had enough. Preparing now to retire.
Everything is not great. 30 years more to go.
Already, see, this year I'll complete 48. I will go well practice. Getting better. I'll complete on 16th August 48.
Wait, don't go by age. Numerical age.
So practice, not age, yes. But it tells on you. Age has started telling, you know, I have a here, pain there.
Another 10.
Difficulty.
Another.
You have good friends, ask them to box you. Some pain here and there will go away.
We will boost him, my lord. for another time.
Who's not talking about?
You also join him on a cycle. I still remember. And
Unfortunately, it appears that the points that I'm raising on the top point on the interpretation of section 20 was not argued before the trial court. And therefore, I don't see any finding. But what I see, a finding which of course I'll have to refer it to 4 times with section 18, section 121A, I have to refer. So I will refer that finding. That will help the lordship in interpreting section 20, although 20 has not been dealt with. I will therefore take your lordships to para 84 of the judgment, volume 5, is placed before your lordship. 84. Given. I've asked him to give, he's ready. At page 990. On the one hand, page number 990, paragraph 84. It was argued on behalf of the defense that there was no trace of any material against the accused under section 16, 17, 18, 18A, 18B of UAP Act. Section 16 of the Act provides for punishment for committing terrorist act. The terrorist act has been defined under section 15 of the Act, and on appreciation of the evidence as done in the preceding paragraph of the judgment, it appeared that indeed there was no conclusive proof that accused committed any terrorist act. The learned trial court didn't stop here. Proceeds further to say there was some evidence of extreme organizations did some violence in Manipur, but that would not prove the commission of any terrorist act by the accused who are facing trial in this case. There was also no circumstance on record to show that any specific terrorist act was committed on the direction of the leadership of UNLF. In other words, this terrorist organization was not involved in terrorist act as per the judicial verdict of the trial court. So there is a clear-cut verdict that no terrorist act was committed at the behest of the leadership of UNLF. So UNLF was not involved. There is a clear judicial verdict. Now, how the punishment was awarded under section 820, my lords will can see at page 83, the previous page, 989. 989. Paragraph 83. It was therefore clear that the prosecution had been able to prove beyond reasonable doubt that accused number so and so are members of the UNLF banned organization and A19 was chairman. All these accused are therefore guilty under section 20. And the next para he holds that a terrorist organization is not involved in a terrorist act. So only because I'm a member, which on a bare reading of section 20 would not say, I would not provide that mere membership is punishable. Now I'll go to the second point. Rather, it will be the first point. Now, as I may not submitted, there are two ingredients of section 20. The first, as I said, is the person must be a member of terrorist gang or terrorist organization, and second is which is involved in terrorist act, the organization. The second one I have already placed. I'll come the first on the first point, my lord. Now, in order to prove that the accused persons are member of the terrorist organization, the prosecution has relied upon the emails and attachments. Emails and attachments. As well as the evidence of PW 9, 17, 39, 61 and 63, 9, 17, 39, 61, and 63. Well, 61 and 63 are employees of 39. The trial court did not even discuss. So I'll confine my argument to the statement of PW 9, 17, and 39. The first point that I would place before Lordship is emails and attachment. Whether the prosecution has been able to prove from these emails and attachment that the accused number 6, appellant before your lordship, is member of a terrorist organization, namely UNLF. Before I go to the specific email which have been relied in case of 6, which are only 2 emails, that won't take that much time. I submit before lordship that the emails and attachments relied upon in its entirety are not admissible in evidence because there is no certification under 65B of the 4 of the Evidence Act. If I look at one. Now, well, first, I don't need to take your lordships through section 3, 59, 65A and 65B of the Evidence Act, because this is how the emails became admissible in evidence. Section 3, your lordships will know of the Evidence Act, that following the IT Act 2000, all right, I'll pace it. Your lordship will have Evidence Act. Compilation 2. Let me take compilation 2. Yes, yes. Yes, yes. Yeah, very good. Where it is. Now, section 3, only thing page will not tally. No. I'll refer first section 3 at page 48A of the compilation. Section 3, your lordship will just see there. Then your lordship will go further down. Below evidence. Evidence, your lordship. Evidence means and includes. Page 48B it is. My lord is having yes. 48B. My lord, it's here at 45B. At the bottom. 45B. 48B. Compilation 2.
That's what.
In the compilation, it starts, compilation 2 starts at 48. ये तो तीनटा एक साथ ही रखा। Evidence Act starts with 48. Section 3 starts at 48 capital A. Then your lordship will go to the next page. Next page. Next page is 48 capital B, my lord. The last, evidence. Evidence means and includes. We are concerned with 2. All documents, including electronic records, produced for inspection of the court. Such documents are called documentary evidence. So, if your lordship will see on the top 6, by amendment, this was by amendment, my lord, of following 2000 at IT Act, Information Technology Act. Then your lordship will go to 59, section 59 of the Evidence Act at page 49. My lord. 59 says, page section 59, proof of facts by oral evidence. all facts except the contents of document or electronic record may be proved by oral evidence. So no oral evidence for proving the electronic record. It excludes. Then, my lord, we'll go to 65A. 65A, your lordship will find at page 52. Page 52. Sixty-five A says a special provision as to evidence relating to electronic record. The contents of electronic record may be proved in accordance with the provision of section 65B. And section 65B on the same page below, if your lordship will see. Replace it. Admissibility of electronic record. Notwithstanding anything contained in this act, any information contained in any electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer, hereinafter referred as computer output, shall be deemed to be also a document if the condition mentioned in these sections are satisfied in relation to the information and computer in question, and shall be admissible in any proceeding without further proof of production of the original as evidence or any contents of the original or any of the facts stated therein of which direct evidence would be admissible. Now, similarly, 2 is also essential conditions, but the certificate which is required is, your lordship will find in subsection 4 of 65B. Any proceedings where it is desired to give evidence, give a statement in evidence by virtue of this section, a certificate doing any of the following things to say, that is to say, identifying the electronic records containing the statement and describing the manner in which it was produced. The electronic record must be identified. Then B, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that electronic record was produced by a computer. Then C, dealing with any of the matter to which conditions mentioned in subsection 2 relates. So subsection 2, 65(2) becomes important because of this, because the information contained in 65(2) are essential, mandatory. I'm not reading whole thing because I'll be proceeding, and these things are mentioned in P.K. Bashir's case on the requirement of 65(4)B certificate. So my submission is that the electronic records that they have produced, in this case, this is email, are not supported by a certificate issued under section 65(B)(4). This is my submission. No, I'll first place the disclosure memo. I'll place first. How the emails were recovered. Now, it is the case of the prosecution that accused number 18 and 19, they made disclosure statement. And because of the disclosure statement, these emails could be retrieved. So I'll first take your lordships. We are concerned here with 18 only. Disclosure memo, the emails which were retrieved on the basis of 27 statement, section 27 of Evidence Act recovery. We are concerned only with 18. When I go to accused number 24 in item, which item? There accused number 19 will also come. So I will confine myself to 18 here. Now, my lord will kindly take compilation 1. Take your lordship through the discovery memo. At page 69, capital A.
Yes,
69, capital A. Section 27, your lordship will have the experience. Nowadays, and from 161 statement only, what is led to distinct recovery, that used to be exhibited. And those will be produced before IO, whether he has made this statement. Same thing like, that's right. That because in that case, there was one case I was doing before court number 1, Mohit Hojai's case. These things came up. In fact, we produced a judgment by this honorable court division bench in 60s, where says this is the requirement. So, and even otherwise, if 27, if my lord will read, so far as the statement which led to distinct recovery of the material, only that will be admissible. Here, they have disclosure memo, and they will put everything there, including admission of the guilt. So 69A, I will just put the relevant thing. Now, it appears that this accused number 18 was using 2 email ID. Your lordship will see 69, the last paragraph, 3 lines. I can recover the aforesaid communication made wide their emails, that is greenplate09@gmail.com. And the second is greenfield006@yahoo.co.uk, if given access to the computer. So these are the 2 IDs that he was using. We are not saying, disputing anything, my lord, under section 27. The second one is green_field 006, green plate. Both are green, just nearby, in the same paragraph. Yeah, it is green plate and green field, these 2. So these are the 2 emails which he disclosed. Now, your lordship I'll take your lordship through the recovery memo. That is at page 70. This is exhibit 112. And the earlier one was exhibit 111, Discovery, disclosure memo is exhibit 111. And this is exhibit 112. Page 70. Your Lordship has noted down the date of disclosure memo. It is 18/11/2010. Exhibit 111, which I just placed at page 69, capital E. 18/11/2010. I'll proceed towards the middle. Twelfth line from the top. Thereafter, the details of mail appeared on computer screen. Your Lordship got it. The printout of the screen appearing on the computer panel was taken. This is immaterial. The printout of the screen was taken. Thereafter, the accused was asked to open email available in inbox, email sent to the others, as well as emails available in the draft. The accused voluntarily provided passwords, so and so, and this I'm unable to read. Out brushing or what to open. Oh, acha. All right. Okay. To open some of the password protected files. This is important, my lord. The printouts of each of the emails sent, received, available in the draft were taken. These printouts were numbered from serial number 1 to 2781 and were signed by the aforementioned independent witness. Since the accused complaint of easiness, the proceeding of transferring the contents of email to a sterile hard disk was postponed for tomorrow, that is 1910. So there are two recovery memos pertaining to same disclosure. So this is first one on 1811. The next one was 1911. And your Lordship has seen from here, green plate, they have taken the printout. Then next, if your Lordship will go to page 72. 72. I'll read just top four lines, then I'll go to the relevant one. In continuity to the disclosure memo dated 18/11/2010 of the accused in custody, Moiran Joy Singh, so and so, today, that is 19/11/2010. So this was 19/11/2010. Then, my lord, will go to 12th line from the top. It's literally 12th line, I think I have counted. Sri Satish Chand, DSP NIA. was provided a sterile hard disk in seal with marked segregate of 500 GB, so and so, Lordship got it, and requested to check whether it contains any data, virus, or any other defect. Shri Satish Chand and Shri Shiva Prasad Mohanty opened the seal of the hard disk in presence of the independent witnesses, confirmed that it is sterile, does not contain any virus, so and so, and is in good condition. Shri Satish Chand and Shiva Prasad Mohanty, one is PW 53, the other is PW 74. Were requested to transfer data available in the aforesaid mail opened by the accused in custody to the hard disk. Accordingly, Shri Satish Chand, his PW 53, and Shiva Prasad Mohanty transferred the contents of the mail to hard disk. The said hard disk was wrapped in a piece of cloth and sealed off with a seal of NIA. The impression of the seal were taken on a plain ink in lac, and papers were signed by aforementioned witnesses. The seal hard disk was signed by the accused, witness, as well as the team members. After sealing the hard disk, the seal was handed over to Sri Rajesh Kumar Singh for safe custody. He is an LIC officer. After transferring the contents of email, the accused in custody asked to sign off the email account. Thereafter, next page I'm reading, thereafter, the accused in custody voluntarily stated that he is having another email, that is Greenfield 006. However, the contents of these emails used by accused in custody could not be retrieved, and he was not able to provide password. So nothing was retrieved from the second one, that is Greenfield 006. That is the end of Greenfield 006. It's not in evidence. So what is in evidence is email said to have been printed at NIA office computer. Now, PW 53, yes. Yes, my lord, yes, yes. 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 That was, your lordship is reading in page 70. Yes, yes, correct. No, nothing is there. Serial number 122781. That's all. And your lordship is surprised to see these certificates which have been issued. I'll place the certificate. Another interesting thing your lordships will notice, these emails were admittedly in Manipuri language. That is in the statement of PW 79. He is the inspector or DSP of NIA. And he said he got it translated. But selective translations have been produced. Who translated it is also a mystery. He said it was translated. Then he says we have taken it to an assistant professor who is in Bangalore. He is well versed with Meithei language. And he has authenticated it, and he has issued a certificate. No certificate is unsigned. The person, they say it's a protected witness. He has not been produced before the court. At the same time, there are two more protected witnesses, PW3 and PW4. They have been produced before the court through video conferencing. I don't know, maybe the face must have been seen. And they were permitted to be cross-examined, but PW80 was not examined. And more interesting thing is, these have been admitted in evidence by the learned trial judge saying that all the accused persons are Manipuri, they know Manipuri language. If there was any translation was not correct, they would have pointed out. The question is, learned trial judge is to adjudicate whether the contents of email makes out a case or not. There is nothing on record to show that the learned trial judge was well versed with the Meitei language. There is nothing. And all these emails were not produced. When we filed an application before your lordship, then my lord passed order directing the office to provide all these emails. Some emails that to the translation, unauthenticated translation was produced. The others said not available. There is a record. It's in. I'll just give, because I don't want your lordship to scupple through the record. I have your lordship's order dated 4/8, 4/8/2023. That day I was not there, my learned friend was there. I don't appear before Justice Kardak, so I did not come. And this is the office note. Sorry, it will be given. Okay. Now, they have furnished this, some emails here. Not even single 115, which is relevant to AC is there, exhibit 115 series. Is they have given to my lord, your lordship, one copy supplementary paper book to me and to him also. This will be. This is supplementary. Supplementary. This will be Aneka. Supplementary. It is. I'll not be referring, I just want to show. Because in my argument, I'm going to attack these emails. They're not even authenticated. Apart from that, it is not certified under 65B.
Part 1, Part 2, 9, supplementary.
Supplementary belek kya hai मेरे को? हाँ, ठीक है. I am not going to refer in रखे दिया. Now, my lord, I will take your lordship. 115, we are concerned with exhibit 115 series and attachment. Yeah, he doesn't have. Well, he has checked, my lord. Whatever was there, they have given as per their note. That note your lordship has seen, no? If your lordship takes your lordship's order dated 4/8, and there your lordship will see exhibit 115 was in our list, which your lordship have mentioned here. It's not there, then we cannot. Index is there, but
It's given in seriatim.
not one, series. It is not here.
Given.
And what is not given is reflected in your lordships. Those are not here. No. Towards the middle, your lordship will see emails 115, 129 to 154. And then 150, from here, 155.
Continue.
Yes, yes, because in the minor copies, type copies, the lordship knows better than me in this. If it is taken out from the computer, there are IP address. There will be date, there will be time. But in the type copy, nothing is there. In few that I have tried to see, I'll place this before the lordship. It's in the office order, if your lordship will see. Moreover, some exhibits given in the list are not even part of the original scanned copies of LCR. Yes, yes. My lord will record and may not sign. I'll see and I'll get back and show it to your lordship, because hearing will be a problem. So what I will do, your lordship will record. If there is anything to be added, I'll point out to your lordship.
Okay, now you'll get it. It's a bit small. Okay, you'll get it now. You're getting it now. Okay. Mr. DK Das, Senior Counsel. Assisted by Ms. GD Chaudhary, Counsel for Respondent is present. List on. When?
Monday? We'll come back to your lordship's convenience.
Okay, Monday. As part of matter. Now, second part is submissions. The learned senior counsel for the appellant has extensively referred to the provisions of section 20 for section 30 35 2 within bracket K, 2 within bracket L, 2 within bracket M, section 10, look in serial order of the unlawful activities within bracket prevention, bracket close act, comma 1967, again a bracket, hereinafter referred to as UA within bracket P, bracket close act 1967. Is also referred to the provisions of section C within bracket 5 of the terrorist and disruptive activities within bracket prevention, bracket close act 1987, within bracket hereinafter referred to as TADA Act, bracket closed. Post, next paragraph. Referring to the provisions of section 20 of the UAPA Act, it was submitted that the said provision contains two postulates. Firstly, one has to be a member of a terrorist organization. And secondly, the organization must be involved in a terrorist act. So referring to the provisions of the schedule appended to the UAPA Act, read with section 35 of the said act, comment was submitted that it is by way of an executive action that the government is empowered to include a particular organization to the schedule without subjecting the said without the said action being subjected to the scrutiny of a tribunal. Next paragraph, referring to the provisions of section 20, 10 A within brackets small Roman 1, section 20 and section 35 of the UAP Act, it is submitted that although they all broadly refer to offense relating to membership of the terrorist organization, but punishment prescribed in all the three provisions are different. Accordingly, it was submitted that in order to have a different punishment in respect of all the three provisions, there must be some inherent differences. Full stop. In the said connection, it is submitted that it cannot be accepted that for being a member of a terrorist organization, without linking it to a particular terrorist act, a person would suffer life imprisonment under section 20 of the UAP Act, and although one is involved in the activities of activities in furtherance of the objects of the terrorist organization, he would suffer imprisonment for a term not exceeding 10 years, as provided in section 38 within bracket 2 of the UAP Act. And that a member who continues to be a part of the any person who continues to be a member of the unlawful association would suffer imprisonment for a term for 2 years, a maximum period of 2 years, as prescribed under section 10(1), 10(b). No, it's 10(a)(1). Accordingly, it is submitted that the concerned accused, the prosecution would have to prove that not only the accused was a member of the is a member of the proscribed organization and was also involved in activities of such association. As provided under subclause Roman 1, 2, 3, and 4 of clause A of section 10. And in relation to offense under section 38 of the UAP Act, it is also required to be shown that he has committed offense relating to membership of the terrorist organization. Correct?
But 10(a) Roman 1 is followed by 2, 3, 4 all are or. So I am not submitting anything against 10A Roman 1, which makes mere membership of an unlawful organization punishment. Because this is what Supreme Court has held in 2023. There I'm not. There it is simple membership under.
No, you are distinguishing it. You
I'm
are saying
distinguishing-
membership and then we are only
I'm
distinguishing.
distinguishing between the membership simpliciter as provided under 10A Roman 1 and membership of a terrorist organization as provided in 20 and 38.
That's what I'm mentioning. Because I'm saying that there's a distinction in the punishment and therefore you are trying to distinguish it. And I'm saying that in respect of 38, it should be an act committed in furtherance of the unlawful activities, or he has committed an offense relating to membership of the terrorist organization.
Yes, by propagating, to be associated with the terrorist organization.
No, for that I have referred to this ABCD. So 1, 2, 3, 4 of 10.
That is.
It will not be there. So we have to set separately. Don't say 1, 2, 3, 4.
38, if your lordship will come to section 38. Section 38 is a person who associates himself or professes to be associated. So he will be guilty only if he associates himself or professes to be associated.
Okay, the 1, 2, 3, 4, just like it out. You say that only and in order to convict a person under an accused under section 38 of the UAP Act, the prosecution must establish that he had associated himself or professes to be associated with a terrorist organization with an intention to further its activities and commits, and that he also and of the God, he also has committed an offense relating to membership of a terrorist organization. Okay. So by referring to the provisions of section 35 of the UAP Act, committers submitted that the prosecution must prove that the accused is involved in a terrorist act. So it was submitted that In running, which is the paragraph you have relied?
In belief, I relied paragraph 10. Paragraph 10. Compilation 3.
Yes, page 5.
And
So this is the question. Moreover, even if assuming that PFI is an illegal association, that is the question.
well, in fact, running is not on 3F, 3.5. It's on 10A.
10A.
Then relevant would be run Arup Bhuiya. Arup Bhuiya was 3.5. And in paragraph 8, at page 8 of the compilation, it says, this is what I have written.
Yes,
So
okay.
this is
So, by referring to the judgment rendered in the case of Arup Bhuiya, ARUP, BHUIA versus State of Assam, comma, within bracket 2011, bracket close 3 SCC 377. And by referring to paragraph 8 thereof, comma, it was submitted that an observation was made by the Supreme Court of India to the effect that section 3 within bracket 5 of TADA. No, sorry, the TADA code had convicted the appellant under section 3 within bracket 5 of TADA, which makes mere membership of a banned organization, comma, criminal. It is submitted that the said observation was followed in two subsequent.
the interpretation of section 3.5 was made in Kalpana's trial before this, where he says two postulates.
No, you are saying that there are three judgments which are incorrect.
Yes.
So I'm referring to those.
One is Ranif, which is on section 10A, Roman 1, which actually I'm not concerned. I have referred it because in the judgment your lordship will find it will Arup Bhuiya second. This has been mentioned. Then Arup Bhuiya is the relevant one. Then Indra Das, it is there. Again, 3.5. Page 10 of compilation. The relevant is the paragraph 27 at page 19.
Just a moment. What I'm writing is, Mr. Mishra, first I've referred to that Arup Bhuiya, and I've said that you said that there is this reference to 3.5, and then you are saying that this same observation continued in two more cases. That is one is
That facade is 20, not 3.5, similar to 3.5, but not 20.
Indra Das.
Yeah, Indra Das. These Arup Bhuiya and Indra Das, in this case, 3.5 was referred.
And this was followed by observation made in the case of Indra Das versus State of Assam, within bracket 2011, bracket was 3 SCC 380. So it was
Paragraph 27.
it was further submitted that where is the judgment of Tawa Fasal? Tawa Fasal is
87.
87.
Paragraph 10 is at 95. It deals with 20, which is parameter area to 3.5.
So it is also submitted that in the case of the case of Hawa, THWAHA, Fasal, FASL and others versus Union of India, comma, Manu MANU, /SC, /1000, /2021, comma, decided by the Supreme Court of India, dealt with the provisions of Section 20 of the UAP Act, which is almost paramateria to the provision of Section 3 within bracket 5 of the TADA Act.
We mentioned Kalpana.
Full stop. In the said context, it is submitted that perhaps the decision of Kalpanath Rai,
Compilation 2, page 75.
Kalpana, KLPNATH, Kalpanath Rai versus State, within bracket through CBI, bracket closed, comma, within bracket 1997, bracket 8 SCC 722. So was not placed before the court when the aforesaid cases were decided.
35 is relevant here at page 9. To postulate
Full stop. It is submitted that in para 35 of the case of Kalpanath Rai within bracket Supra, it was held that there are two postulates in subsection within bracket 5 of Section 3 of the TADA Act, to the effect that firstly, the accused should have been a member of the terrorist gang or terrorist organization after 23/5/1993, and the second is that the said gang or organization should have involved in terrorist acts subsequent to the said date, and that unless both postulates exist together, comma, Section 3 within bracket 5 cannot be used against any person. Full stop. It is next para. It is also submitted that the the case of Arup Bhuiyan within bracket Supra was referred to Al-Hajar bench, and accordingly, the three-judge bench of the Supreme Court of India revisited, examined the decision in Arup Bhuiyan versus State of Assam and another, and the order of the court reported in the case of Arup Bhuiyan versus State of Assam, 2011 within bracket 3 SCC 377 was recalled. So and Indra Das versus State of Assam, 2011 within bracket 3 SCC 380 were recalled. Accordingly, it is submitted that in the said case of Arup Bhuiyan within bracket Supra, report Arup Bhuiyan within bracket 3, Roman 3, comma, the interpretation of the provisions of section 10 within bracket A within bracket 1,
What's the meaning?
as well as section 3 and section 4 of the UAPA Act.
Type was not an issue as per section.
No, but this is what they have decided.
Yeah, we have decided.
Then I'll record your study. Was in interpretation also was given. So in the said context, it was submitted that in the entire judgment, there's no reference made with regard to the provisions of section 3 and 5, 3 and 4 of the UAP Act. And therefore it is submitted that the observations made regarding the provision of section 3 and 4 of UAP Act cannot be interpreted to be the ratio of the said judgment.
Lordship has said a rule under Bhunya 2. So therefore, your Lordship mentioned the 3. So your Lordship mentioned 2, that it was referred.
No, I've just referred, I'm not saying that too, but it has
Your
been,
Lordship has just
no, 3 is the larger bench.
larger. So there will be 2 also. No, first is that.
No, first is 2, then it is referred to a larger bench. I have not stated the decision, but I have come to 3.
Because here also Arup Bhunya, 2015.
No, I understand, but it's not relevant because I have said in one place. I've said it has been referred and it was taken up by 3-judge bench. In context of placing the judgment of the case of Arup Bhunya within bracket 3, within bracket supra, the learned senior counsel for the appellant has laid stress on paragraph 14 and 23.2 of the said judgment. Accordingly, it is reiterated that section 20 of the UAP Act cannot be read to mean that for merely being a member of the terrorist gang or organization, one can be punishable with life imprisonment even without a finding to the effect that a terrorist organization is involved in a terrorist act. Stop. In order to explain his submissions, it has been submitted that in the schedule of the UAP Act, there are 5 listed terrorist organizations for the state of Manipur. Accordingly, he has submitted that it cannot be the intention of the legislature that if a terrorist activity happens in the state of Manipur, notwithstanding who is the culprit, or whether any terrorist organization is involved in the terrorist activity, all members of all the terrorist organizations cannot be arrested and charged for committing an offense punishable under various provisions of UAPA Act. It is submitted that in the present case in hand, the learned trial court, though had held that the appellant was not guilty of any terrorist act and was acquitted for committing offense under section 16 of the UAPA, they were held guilty of being members of the terrorist organization and inflicted with the sentence without connecting the appellant to any particular offense.
I refer to section paragraph 84, where the learned trial court held that even the association, there is no evidence that association is Lordship was seeking.
Okay, 84. Which page?
What is page 98.
990 that.
The specific that established organization is not involved in any terrorism.
Okay, it is also submitted that in paragraph 84 of the impugned judgment, there are three specific findings. Firstly, to the effect that there is no conclusive proof that the accused had committed any terrorist act. Secondly, although there was some evidence that extremist organizations did violence in Manipur, but it was held that it would not, but that alone would not, but that would not prove commission of any terrorist act by the accused who are facing trial in the case. And thirdly, there was no circumstances on record to show that any specific terrorist act was committed on the direction of the leadership of UNLF. And accordingly, it was held that the appellant was not guilty of commission of offense under section 16 of the UAP Act. Okay. Next paragraph. Mr. Mishra will break because the only now what is left is that the appreciation of evidence will continue next day. This part is okay?
My lord, what flows from 84 is that the terrorist UNLF is not involved in that.
That I have already recorded.
Means nothing. Earlier we don't know, but presently it's very clearly mentioned.
Okay.
So what flows from it is this, as I'm not in.
Okay.
So merely
So
because
accordingly, it is accordingly
executive
submitted that
says that,
from the finding written in paragraph 84, what flows is to the effect that that UNLF is not involved in any current, is not involved in a terrorist activity for which the accused were charged. Correct? Well, otherwise there will be a tendency to forget. That's why.
No, I've continued till.
No, not that.
Yeah,
That's
yeah,
why I
okay.
dictated.
Production list item 1 for delivery of order.
I read that the court having decoded the applicant by passing a judicial order which was implemented, the order of the court which has been implemented cannot be undone by subsequent order of the same court. And therefore, in light of the discussion, however, the court is of the considered opinion that the applicant has not been able to make out a case for modification or alteration of the order dated 27/1/2023. There's some corrections, we'll get it after some time. But you can see it. No, it is no issue, but. No. Correction is.
Oh, that is. Yeah. Item 1, supplementary cost list, single bench.
There are mistakes on the case record not received. Case record not received, so registering with that to.
No, it has been received. It is there.
for this instruction.
We had not called for the records because this order sheet after 9/10/2023 we had called, and that is available.
Any other result, I was told that LCR was called.
No, not the entire LCR, because we have specific order, a trial court, we have written like this in the order. The status of trial is available till 9/10/2023. Therefore, the registry shall call for the order sheet of the NDPS case number so and so after 9/10/2023.
This is our mistake.
No, it's not question of mistake. We are not finding fault. Absolutely. You wanted, we'll take it up Monday or Tuesday? Tuesday? Okay. Both sides are duly represented. As agreed to by both sides, list on two. Sorry, it'll be 6/2/2024. Okay, no, not an issue.
Item 2.
Yes.
Out of 8 witnesses, my lord, 6 witnesses are examined. My lord, my case before your lordship for filing the second bill application is specified, my lord, on there was a judicial order prayer made by the IO to collect the DNA sample with regard to analysis of the blood connection, my lord, on 1 March 2023. And the sample was collected from the accused petitioner on 10 March 2023. But till date, the same is not before the honorable court.
No, that in bill application, we can't do anything.
And my regard to the length of detention of my lord, length of detention that these witnesses, my lord,
Okay, arrested on?
my lord, I was arrested on my lord. 15/8, my lord, I was arrested on 15/8/2023.
15/8/22.
2023.
How many days today?
My lord, it's on today 5:35 days.
No, length of detention we can release because his
Trial is going on.
no, because principal witness have been examined,
Yes.
but his 535 days. Grant him bill then. Miss S.G. Parvanan counsel for the petitioner, as well as Mr. K. Boishwar Leonard, APP for the state. This is the second bail application by the petitioner under section 439 CRPC for enlarging him in bail in connection with Kalaigaon PS case number 72 of 2022, corresponding to GR case number 489 of 2022, under section 376 within bracket 3, IPC read with section 4/6 of POXO Act, which is being tried as special within bracket POXO, bracket close, case number 22 of 2022 by the Court of Learned Special Judge Dalguri. Next, the previous application for bail was rejected by order dated 17/2/2023, passed in BA 123 of 2023. At that point of time, the petitioner had been in jail for 185 days. Full stop. It is submitted that as on date, as the petitioner was arrested on 15/8/2022, he has suffered custody of 535 days. Full stop. It is also submitted that in course of trial, out of 8 witnesses, 6 witnesses have already been examined. Next, the learned APP has referred to the scanned copies of the LCR, which were obtained in connection with BA 123 of 2023, as well as the documents annexed to this bail application. And it is submitted that there are sufficient incriminating materials to show that the petitioner had sexually assaulted a minor girl, minor victim, and the victim had also delivered one baby on 3/11/2022. First of, accordingly, it is submitted that the petitioner is not entitled to be released on bail. Next paragraph. On a consideration of the projection that the petitioner was arrested on 15/8/2022 and has suffered incarceration for 535 days as on date, notwithstanding that there are materials in the case record against the petitioner, but as an trial, having spent 535 days in custody, from the court is of the considered opinion that the petitioner has become entitled to be released on bail. So accordingly, the prayer for bail is allowed. Next paragraph, it is provided that in the event the petitioner furnishes proof of his address as well as on furnishing a bail bond of rupees 1 lakh with one surety of like amount to the satisfaction of the Learned Special Judge Poxo, Dalguri, he shall be released on bail on following conditions. That condition will daily appear on each and every date. So that in the event of default in appearing on any date without lawful excuse, it will be open to the Learned Trial Court to cancel bail and to take the appellant into custody, petitioner into custody till the conclusion of trial. Full stop. In the event the petitioner cannot appear before the trial court for any compelling reasons, he would ensure that he is duly represented by his learned counsel and would not pray for adjournment, and the counsel for the petitioner shall participate in the proceedings by cross-examining witnesses were available. The conditions are there. Next are the records of DA 123 of 2023 may be detached. Yes, Mr. Prahat, what to say?